Does a person who was found incapacitated and in need of a guardian under Mental Hygiene Law Article 81 lack testamentary capacity to complete a last will and testament? To find out, you have to read Matter of Samuel, but it's 8 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I normally cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Matter of Samuel. The citation for this case is 2024 New York Slip Opinion 24014, published by the Kings County Supreme Court on January 11th of 2024. This is an interesting case. It deals with a lot of different issues. In particular, it deals with the use of AI in motion practice and summary judgment, as well as comparing Article 81 incapacity with testamentary capacity. I'm going to get into all those things in just a moment. The background law that's helpful to understand this case is first, summary judgment under CPLR 3212 is appropriate. Basically, it's a motion to terminate the case in the favor of the party moving for the summary judgment if there's no disputed issues of fact that are needed to be resolved at a trial, and on the facts that are basically not in dispute, the side that's moving for summary judgment is entitled to prevail. So a trial or a hearing is supposed to resolve disputed issues of fact, but if there aren't disputed issues of fact, then summary judgment is the appropriate vehicle to basically terminate the case without a trial. Next is Article 81 guardianship, and Article 81 guardianship under Mental Hygiene Law Article 81 is basically empowering a guardian to take care of the personal needs or property management needs of an alleged incapacitated person if there's both necessity and either a person consents to the appointment of a guardian or there's a finding of incapacity. And that finding of incapacity has got to be based upon the inability of the individual, the alleged incapacitated person, to perform activities of daily living and their inability to understand and appreciate the consequences of these lack of ability to perform the ADLs that are needed to be performed to survive, and that this harm is going to result if a guardian's not appointed. That's the necessity part. And there's a second kind of incapacity, which is called testamentary incapacity. Incapacity with regard to testamentary capacity is basically assessed with regard to this. Testamentary capacity exists when the person who's executing the document can think with sufficient clarity so that without prompting, she can understand and carry out the business to be transacted and can hold in her mind the extent and nature of her property and the natural objects of her bounty and their relation one to the other. If that exists, even for a brief moment of time, then that person has testamentary capacity. And lastly, there's an issue of what undue influence is. Undue influence is a concept. It's got 3 elements. If there's motive, opportunity, and actual exercise of the influence, then a testamentary document, a will, can be thrown out as being the product of undue influence. But the proponent has to show and demonstrate that the influence amounted to moral coercion, that it's not actually the free will of the person whose document it is. That's the burden. It's a very high burden. What are the facts here? The facts are that the decedent's name is Phylliscita Samuel. Phylliscita Samuel executed a will in 2012. We'll call that the 2012 will. In September of 2014, she was the subject of an Article 81 guardianship. Someone said she was incapacitated, and she was found incapacitated in September of 2014, and a guardian was appointed. 1 month later, Phylliscita Samuel executed the 2014 will, right? So a month after she was declared incapacitated sufficient to justify appointing a guardian, she executed another will, the 2014 will, in which she named her guardian as her beneficiary and executor of the will. She died in 2016. So after she died, her will, that 2014 will, was offered for probate, along with the death certificate and the affidavit of domicile. And Osborne is the litigant in this case, Osborne and another person named Samuel. Osborne came forward and filed a motion to deny probate and to grant letters of administration. Instead of the will being offered for probate, they wanted the Supreme Court and the Surrogates Court to issue letters of probate. Samuel, which filed a cross petition, this is a relative, I assume, of Phylliscita Samuel, filed a petition to probate the 2014 will. So now you have litigation One person wants to throw the 2014 will out. The other one wants to probate it. Osborne then filed a motion for summary judgment based upon the fact that only 1 month before the execution of the will, she was declared incapacitated under Article 81. And there was motion practice. And the last reply by Osborne had 6 citations, and 5 of them were fake citations, were citations either to cases that didn't exist or were erroneous citations. And basically, it was determined, it's concluded that these are probably the product of generative AI, of artificial intelligence, basically doing motion practice instead of the lawyer doing the due diligence and research that's required of motions. So what's the holding here? What happens in the holding? First, the first question is, what is the impact of the false or erroneous citations included in this reply paper? And the court basically kind of assumes that it's generative AI because simple and part of the process here is a simple Lexis search or Westlaw search, which are research engines that lawyers use, would have found out these were fake citations in 1 second or a few seconds. So the judge goes through the many harms of using AI in legal papers like this, and basically says this is sanctionable activity. So it's frivolous activity, which you're not allowed to engage in frivolous motion practice or frivolous activity. The judge strikes the pleading, strikes out that reply, and schedules this after. Says, I'm going to schedule this later for a sanction hearing to determine what kind of sanctions, if any, should be applied to the lawyer who did this. But the next 2 issues are the legal issues that are interesting. First, is summary judgment appropriate with respect to capacity and with respect to the undue influence? And the questions here basically are, is its summary judgment is there no disputed issues of fact that if a person's declared incapacitated in September, they don't have capacity to sign a will in October, 1 month later? And the answer from the judge is no. Article 81 incapacity is different than testamentary capacity. They are different. They are not the same. So it doesn't resolve the issue. He's not resolving it saying that there was capacity, saying this is not resolvable on a motion for summary judgment. Let it go to the finder of fact. Let it go to a jury. So that's the first question with regard to the law. And the second summary judgment question is it summary judgment worthy to find undue influence based upon the fact that the guardian is the beneficiary and executor of the will that was executed 1 month after the guardian was appointed guardian? And the answer to that question is no. The judge says there's no rule prohibiting, in Article 81 of the mental hygiene law, prohibiting a guardian from being an executor or beneficiary of a subsequently completed and executed will. So I'm not going to create new rules prohibiting things that were already done and allowable when they were done. So that doesn't take away an issue of fact. That fact also can go to the jury, not resolving it conclusively, but saying it's a disputed issue of fact. Let it go to a jury. And that's the case of Matter of Samuel. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.